the Internal Affairs Unit of the National Police Service, a creature under the National Police Act, Section 87.
Yes. Now we'll take you back to law school.
Yes, yes.
If it is a preliminary objection, then you needed to tell me that you are raising a preliminary objection on points of law and with respect to the purpose, and then whether you are going to go full, through the application fully, so that I know whether you have notified me is also ready. Then we put our house in order. Now, kindly note prosecution counsel.
Yes,
this is a preliminary point of law, but on what purpose? What are you objecting to?
We are objecting simply.
Yes.
Internal Affairs Unit of the National Police Service Commission is purporting to appear before you on matters it does not have jurisdiction.
Okay, that will be sufficient.
Yes,
that is
now
noticed.
yes.
Then now you can respond.
Thank you. That the respondents, Your Honor, file a formal PO, Your Honor, to enable us response, or in the alternative, whatever directions that courts will give, Your Honor, before we can proceed with this PO, Your Honor.
Yes, let me. This morning. Committed Section 87 get well back with it. If it needs 5-10 minutes, we don't mind. We can come back in 10 minutes and get your appeal and let him respond, because it's just. Do you have the description of it?
I agree with the defense counsel. He does not need to do it in writing. If they are ready and you are ready, it is you who can ask for an adjournment to respond. But that should not, your inability to respond on the spot does not burden from proceeding. Is that okay? Mr.
That's okay, Your Honor. We can proceed with the PO. We will determine, Your Honor, whether.
Although, I need everyone to take a deep breath. I need all of you, and I'm going to take 2 minutes break to have all of you taking a deep breath. It is a court of law, and we all need to be calm, isn't it? We all need to be calm. Now, I also need all the advocates to have somewhere to sit, and I will ask the security detail team to vacate that bench and sit on this side. We will get you more seats so that I can have all the advocates find somewhere to sit. The security personnel, there are 2 chairs here. I also need protection from you, so I need you. Yeah, 2 of you can sit there kindly. There is even another chair here. Now the advocate sit, because I only want Omari on his feet. Thereafter, he'll hand over to the next advocate like that. All right? So I need everyone to take a seat. That is the only way we are going to have a calm audience. Mr. Wangoi, I want you to stop being a bodyguard to Mr. Omari. Thank you very much. Now I am ready to hear you. I'm ready now to proceed.
In the service, 3, keep a record of the facts of any complaint or investigation made. To it, the functions proceed in 3rd, that in the performance of its functions, the unit shall be subject to Article 47 of the Kenyan Constitution. Part 4, the unit shall investigate misconduct and hear complaints, A, from members of the service, or members of the public. B, the unit shall be at the direction of a senior officer. Or C, on its own initiative. D, on the direction of the Inspector General. E, at the request of the Independent Police Oversight Authority. In sub 6, the unit may recommend the following disciplinary actions to the Commission. 1, the interdiction of an officer. 2, the suspension of an officer. C, the administration of a severe reprimand or a reprimand to control or influence the pay, allowances, or conditions of service of an officer. Lastly, any other lawful action. Your Honor, that is the mandate of the Internal Affairs Unit. Nowhere is it contemplated that it can come to this court to seek orders to interdict, to discipline the 4 respondents. Content of the affidavit, which my seniors, Kahiga and Onge and the others will deal with, are not within that purview. This is the purview, and it is public knowledge, and the court can take judicial notice, and from the content my seniors will deal with, is about the abduction of 2 Indians, which is criminal in nature. It has nothing to do with the administrative action of the 4. Therefore, the bodies known by law to bring such an application is the Director of Public Prosecution, who we have given that mandate. The Inspector General, with his investigative powers, not the administrative wing of the Inspector General's office. Article 245 that creates the National Police Service Commission has not donated complaints of kidnapping, complaints of conspiracy to commit a felony to a small entity called the Internal Unit. Your Honor, the reason as to why the Internal Unit is the one before you it is because this is a political matter where the 4 who come from one ethnic community were interviewed by 4 officers from Internal Unit from one ethnic community. That is why no policeman wants to swear an affidavit against them. That is why the good office, the Director of Public Prosecution, is running away from his constitutional mandate under Article 157. Your Honor, the court is being misused to settle political scores. These are mere people, junior officers. Let them face the full force of the law within the parameters provided by the law. In the content, they are being said they did an extrajudicial killing. Article 47, which I have put here and read to you, binds the internal police unit that they must act within the Fair Administrative Act and within Article 50 and Article 49 of the Constitution. Do you have jurisdiction to entertain internal affairs unit? You know, you don't have. You don't have. Next time, Your Honor, you will entertain this matter, the HR unit of the police will come before you in a criminal quasi matter to deal with officers. Let a proper application be done by an entity known by law, an entity known by the Constitution, and we avoid this tribal and political witch hunt that is being vested on these 4 officers. You know, that is all. I will allow my other senior, Mr. Onge, to proceed. We are acting together for the first respondent. Then Mr. Kaiga, because of seniority, will deal with that. Then the young associates should deal with the others.
He has also pointed out the jurisdiction of the body that it purports to come before you. I will not belabor the point. The only thing,
just to remind you that when you raise a preliminary objection,
yes,
it's going to be on pure.
yes, it's on pure points of law.
Yes.
The long and short of it, Your Honor, the long and short of it, Your Honor, is the person purporting to come before you to ask for orders has no locus. And once that individual has no locus, Your Honor, you do not have the hands to deal with it. Decline that invitation at the onset. Don't get mixed up into things that do not belong to this court. That's all.
By my colleagues, in which I adapt their submissions fully, I wish to warn that issues of jurisdiction cannot be resumed. They either flow directly from the Constitution or they are statutorily donated. For purposes of exercising the jurisdiction, the party moving the court must be a creature of law, one known by the law, and the law has donated that mandate to exercise those powers. In that particular case, issues of local standard has to be looked at as to the capacity of the party purporting to move the Honorable Court for certain orders. Because that puts us squarely at the issue of jurisdiction. In the application dated the 24th of October 2022 and filed before this Honorable Court today, the applicant before you is described as the Internal Affairs Unit of National Police Service. As pointed out by my colleague in details, this is a creature whose powers are not flowing directly from the Constitution or the mother law, that is the statute of the National Police Service. This is an internal department within the National Police Service, and therefore, according to the Constitution and the National Police Service Act, this particular creature has no legal mandate to appear before the court and move the court in the manner it has done. For it to purport to do this application and seek these very critical orders that are infringing on the constitutional rights of the respondents, then that will be abrogating the law. It will be trivializing these proceedings, and it will prejudice the dignity of this honorable court to uphold the law as it ought to be. As such, our submission is that this honorable court has now been moved in the manner that the law requires, and that puts Your Honor in a position whereby you are not vested with the jurisdiction to interrogate the issues raised in this application. Now that we are dealing with a creature, a non-entity, not known in the criminal procedure or even the Constitution to make the kind of the application they have made. This is an abuse of the court process. It should not be entertained, and we pray that the Honorable Court do exercise its mandate and stamp its judicial authority and strike out this application. That's all.
Before you this morning. Your Honor, it will interest the mind of the court to also note that other than the National Police Service Act, which creates the applicant before court, Your Honor, there is the National Police Service Commission Discipline Regulations of the year 2015, that expand or rather give a detail or details as to the functions of the internal National Service Police Unit, the applicant. Your Honor, I must further note that the authority of the applicant is purely to discipline national police officers as and when they run afoul of what is otherwise defined as offenses against discipline, as set under Chapter 30 of the Service and Standing Orders of the Police. That said, Your Honor, I respectfully submit, Your Honor, that the very design of law is to give officers and officers certain responsibilities. So much so, Your Honor, that however well-intended the applicant might be, it is not in their place to move this honorable court in the fashion they have moved, and at the very least to seek orders that are in essence meant to limit the liberty of the respondents that are before the honorable court. Your Honor, this honorable court has a duty under Article 20 of the Constitution that while interpreting the Constitution, the court must interpret the Bill of Rights and Fundamental Freedoms in a very generous way, respectfully, Your Honor, in a manner that ensures the maximum enjoyment of the rights and fundamental freedoms that are guaranteed to the accused persons, or the respondents for that matter, Your Honor. Your Honor, it's against that premise that I urge the court that as you consider directing my senior counsel for the applicant to go and organize or make his house in order, that at this earliest stage, Your Honor, you will consider giving the appropriate reliefs to secure the liberty of the respondents before court. Your Honor, some of us have been detained by police officers in the recent past, and we know too well they do not find themselves in a very comfortable position. The court is enjoined by the Constitution to protect their right to liberty, order their release on reasonable conditions as we await the fate, if at all, of the application at the 24th day of October 2022, Your Honor. I rest and I thank the court. Thank you.
For the second and fourth. Your Honor, mine will just be very brief to demonstrate the incompetence of the application before you. And Your Honor, this is premised on the affidavit that is sworn in support of the said application. That Your Honor, when you look at paragraph 2, and even on the face of the application, the said application is supported by an investigator from the Internal Affairs Unit. So that to that extent, Your Honor, even the foundational basis upon which the application is being sought falls with it, because the Internal Affairs Unit, as you have been ably led, deals with the internal affairs of the police service. And Your Honor, the nature of the application and the nature of the order they are seeking is not one that is within the purview of an investigator within the Internal Affairs Unit. Your Honor, based on that defect, I will then be adopting the position taken by my seniors that the Internal Affairs Unit is the wrong applicant. It's not the right party seeking the orders before court. And on that basis, Your Honor, the court should not entertain the application pursuant to the limited functions under Section 87 of the National Police Service Act. That's all, Your Honor.
The application before you, that is the application dated 24th of October this year, Your Honor, is properly before you. The applicant, when you look at the application, Your Honor, you'll see that the applicant is Internal Affairs Unit, National Police Service. Now, Your Honor, the questions that you need to ask yourself in determining this preliminary objection, Your Honor, is 2 or 3 questions. One is whether the applicant is a unit within the National Police Service. And the answer, Your Honor, is yes, and I refer you to Section 87 of the National Police Service Act, 87A, which Your Honor, establishes the Internal Affairs Unit. Number 2, Your Honor, the question that you need to ask yourself is the deponent a police officer here? And the answer, Your Honor, is yes. Mr. Michael Kirui, who is before you, Your Honor, just right here, I'll ask him to just show his face to court. Your Honor is an assistant superintendent of police. He's a police officer, Your Honor. The third question that you need to ask yourself, Your Honor, is whether the 4 respondents, who are they? Are they police officers? Are they civilians? And the question is, they are all police officers. Section 87.2 now says, Your Honor, having answered those 3 questions in the affirmative, 87.2 says that the function of the Internal Affairs Unit shall be to receive and investigate complaints against police officers. Your Honor, so as got to appreciate the context of this application, which Mr. Omari has already highlighted, relates to the disappearance of 2 Indians and 1 Kenyan. And the disappearance, Your Honor, is alleged to have been caused by the respondents, Your Honor, before you. So, when we look at 87.2, is that a complaint, Your Honor? The answer is in the affirmative. Your Honor, there are authorities that have been developed by the superior courts that recognizes Internal Affairs Unit as a unit within the National Police Service and capable of investigating misconduct and criminal activities of police officers. Your Honor, allow me to highlight 2 or 3 of them. One of them, Your Honor, is Elizabeth Gathoni Moremi, and another versus DCIO Nakuru Railways Police Station, and 3 others. Your Honor, this is a 2015 case reported in Electronic Kenya Law Reports.
And could we have what is to find?
It's an authority, Your Honor. I've given the citation. That's why I'm giving the citation, so that they can have have a look.
The young team on the defense team, you are techno-savvy, take note.
Yeah.
Because I think he's also using EKLR
Yes,
online,
yes.
yeah.
Yes,
so take
I'm
note of
online.
yes, proceed.
Yes.
That is one.
Elizabeth Gathoni?
Yes, so yeah, so Your Honor, it is Elizabeth Gathoni Muremi and another versus DCIO Nakuru Railways Police Station and 3 others, 2015 Electronic Kenya Law Reports. Another authority, Your Honor, that again recognizes the Internal Affairs Unit as an investigative agency within the National Police Service is Republic versus Chief Executive Officer, Independent Policing Oversight Authority, and 2 others. Anji Patel, 2019 Electronic Kenya Law Reports. And finally, 2019, sorry, Kenya Law Reports. Finally, Your Honor, I refer you to Republic versus Authorities, Your Honor. Just a highlight that Internal Affairs Unit, Your Honor, is and it has powers to investigate, and indeed it is an investigative agency. Is properly before you, and we pray that you dismiss the preliminary objection and proceed on to hear this matter. In miscellaneous E236 of 2022, 236 of 2022, where court has had an application of this nature and granted the orders, Your Honor. I urge you to dismiss this PO and allow us to proceed with the application, Your Honor. That is all.
What you are being told is that the unit is within the service. The National Police Act creates very many units with specific functions and duties. they still can discipline officers without the court's intervention. We are not challenging that they have their own investigation powers, but limited to discipline, not limited to abduction, not limited to murder. You know, you have been told the deponent, one senior police officer, Michael Kirui, is in court. And among the issues I have raised here, that the officers who investigated these police officers came from the ethnic community of Michael Kirui.
Your Honor, I'll object to this line of questioning. I don't think Your Honor.
Arrest it.
Your Honor, I'll object.
Sustained.
I'll object.
The objection sustained.
Most
Much
of
of
my-
that.
Leave it at that. You withdraw that expansion.
I withdraw that line of thought and put it this way.
Yes.
These officers were never exposed to a fair investigation.
Your Honor, again, I will object to this. Your Honor, the PO is limited on whether or not this application, Your Honor, is properly before you. And in my reply, Your Honor, I did not mention whether they were properly investigated or not. Can Mr. Omari stick to the rejoinder issues and to the rules so that we can save time, Your Honor?
Yes, allow me to guide Mr. Omari as an advocate. He cited section 87, subsection 2, and has given us those two authorities. And he has just made submissions that that unit has investigative powers as per the three authorities he has cited, and that is why I had asked you to sit with your team
They already.
so that you do not get outside. And in that regard, allow me to give you 2 minutes so that you confer. I'm just here so that you can confer and see the best way to respond. The 4 advocates kindly confer. Otherwise, you're introducing new matters.
My lawyers will deal with that angle because they have gotten the authorities, I'm told,
Yes.
they are about employment and dismissal.
Yes.
The
So
lawyers will deal with it.
I will take you back where you had reached, and you were saying that that the agency has its own investigative powers, but it is limited to disciplinary matters, and not matters such as murder
Yes.
and extrajudicial
Killing.
Now you can proceed from there.
And Article 47, which I laid the basis on, expects that unit to discharge their mandate in a fair administrative manner. The 4 are raising that there was no fair administrative action.
Your Honor, allow me. I'm really sorry. Was this part of the PO that was raised? Kindly guide us.
I did raise the question of fair administration.
On fair administration?
I did
Your Honor?
raise, yes, and I read it.
And in my in my reply, Your Honor, did I talk about that?
Not in your reply, yes.
Thank you,
All
Your
right.
Honor. Kindly, let's get guidance, please.
All right, Your Honor, the question that has been brought by my good friend is that the 4 respondents are all police officers. Are they entitled to be dealt with under the Kenyan law? Does the rank of police officer exclude them from enjoying the rights of the law and the Constitution? They are still subjects of the Kenyan law. And the Kenyan law says entities that can come to court are not the internal unit. Entities that can move the court over their complaint is IPOA, is the DCI, through the DPP. Confirmed that the investigation, the application before you, is about the disappearance of 2 Indians and a Kenyan. that purview of what the applicant wants you to give is not in the purview of Section 87. It is within the police service under different departments. Lastly, you have been told that there was another application in E236 of 2022 that was made before and the court pronounced itself. None of the defense team is aware what the issues and facts were in that miscellaneous application, E236 of 2022. This is a novel application before you with peculiar facts. And we urge the court to make an independent ruling based on the submissions and authorities and arguments the defense has presented before you. Can this court depart from its previous ruling if it is true in E236/222? Yes. Your Honor, we urge this court to deal with this matter. Nothing is out of control. The state could have simply withdrawn this matter, walk outside, remove the internal unit, put the National Police Service Commission or the DPP, and the matter ends. We are simply wasting judicial time over a matter that we are determined to pursue to the Supreme Court. The DPP should simply withdraw this application and file a proper application. We deal with it because that is what is known in law. Yana, I leave Mr. Onge two issues and Mr. Kahiga 2 issues. Then the lawyers will deal with the authorities that they have got. Thank you very much.
And I'd like to just deal with those 3 questions. Section 87 that we've cited and before the court, its functions do not contemplate that unit coming before you to seek the kind of orders they purport to seek. You are asked whether it is a unit within the police. Yes, it is. We must be nine. But does it have that mandate to come before you? My colleague rightly told you this. If you entertain this application, tomorrow HR issues will come before you. And the following day, desks and office issues will come before you. This is not the place to deal with internal police issues. Someone else has that mandate, and it is not for the internal unit. The other question you are asked is whether they are police officers, and if they are police officers, they should be brought to you. It's all right, yes, they can, but not by that unit. And finally, Your Honor, 236 of 2022 does not concern first respondent. He's not a party. As my colleague Mr. Mata told you, we do not know what transpired in that matter. And it's not a precedent. It is not a precedent that the court can follow. You're not bound by what happened in 236. We'd like you to look at this application on its merits. I beg to resume my seat. Thank you.
Your Honor, you've been told that mysterious criminal application number 236 of 2022 bides you, and that you cannot depart from such a point. However, the rule of jurisprudence is that every matter must be addressed on its own merits. Issues that were with that matter did not concern the respondents before you. So is the State Council now trying to raise an issue similar to the one of the SSU? Because it's not applicable. Every matter that comes before you has been decided on its own individual and specific circumstances. We are not privy to whatever transpired in that other proceeding. And we do not even know the special circumstances that made you deliver or...
Which case was that, Mr. Kiavia?
We talked of 236 of 2022.
236
Yes,
of
Your Honor. There is the one that you gave a ruling on Friday last week.
So we are not even aware why yourself, in your own wisdom, you pronounced yourself the way you pronounced yourself in that matter. This quite different scenario. This is a different matter that has been brought before you. And you have the jurisdiction to look and interrogate the issues before you. So your hands are not tied, as the State Council would want to make the court believe. Secondly, my colleagues have pointed out, this country is governed by the rule of law. Our constitution and the different statutes identifies various bodies or legal entities with their own mandate, and that mandate cannot be overlapped with another. It is on that basis that the drafters of NPS Act, in section 87, in their wisdom, decided that they cannot donate these particular powers to the internal audit unit and gave it to other bodies, like the POA, the DCI, through the DPP. So it is wrong for IAU to try to over and presume itself jurisdiction that does not flow from the Constitution and the statute. Such is not allowed in our law. They must confine themselves to what the law has donated to them and not allocate or arrogate itself powers that it doesn't have, because that will be acting after bias. When a body acts after bias, it lacks the jurisdiction. It also makes the Honorable Court lack selected jurisdiction to look at the issues it's bringing. Jurisdiction is everything. The moment such a body acts after bias, we don't have to look at the merits of whatever they are bringing. So it's not trite that you've been told some 2 Indians and 1 Kenyan were kidnapped or disappeared, and the allegations of extra judicial killings. What is important is, has the court been moved by the proper person and in the right manner? If such is not the case, as we are submitting that that's a scenario in this particular matter, then you don't even have to look at the merits of this application, if it's not brought within the confines of what the law provides for. It's on this basis that we are praying that we do dismiss this application and release the respondents.
Not made to irritate the court or to our colleague for the applicant. In any event, Your Honor, the application is made so that we can maintain the purity of the law. We can ensure that these proceedings are conducted by persons with the authority under law to move them. Your Honor, I will go straight to the authority mentioned. The first authority, which is Elizabeth Gathoni Muremi and another versus the DCIO. Elizabeth Gathoni Muremi and another versus the DCIO. Nakuru Railways and another. Your Honor, this was an employment dispute. The claimant, Elizabeth Gathoni, was a police officer, was interdicted from employment after allegations of stealing were raised as against her and her colleague. And respectfully, Your Honor, that authority is distinguishable, and regrettably it's made to mislead the Honorable Court. It has no relevance to these proceedings, Your Honor. The second authority that has been mentioned, which is the Republic versus the Chief Executive Officer, ex parte Harishi Pate, 2019 EKLR. Your Honor, again, this is an authority that has been made to mislead you. Simple facts of the case: the ex parte applicant, who is a citizen, was harassed by police officers and moved the Judicial Review Court in search of an order of mandamus, so that the court will compel the Chief Executive Officer of the IPOA to investigate misconduct by the police for harassing him. And so is the other authorities that have been mentioned by counsel before you, Your Honor. Respectfully, Your Honor, those authorities have no connection or bearing with the instant court proceedings before court. They must be ignored. Yes, they must be ignored at the very least, Your Honor. Your Honor, I'm also reminded on my feet that Section 8 and 9 of the IPOA Act bestows the responsibility of investigating the excesses of police, if at all, to that independent police and oversight authority. Your Honor, the applicant cannot remake the law by giving themselves the authority to pursue criminal complaints as against their very own. That is not what was anticipated by the law. Your Honor, my last bit of submission is to humbly direct the attention of the court to Article 87 of the National Police Service that has been made quite a number of reference to. Your Honor, before we rush to subsection 6, I urge the court to make a stop at section 87.3 of that National Police Service Act, number 11A of 2011. Which, Your Honor, if you allow me, just to highlight, it mentions that in the performance of its functions, which this is the applicant's functions, the unit shall be subject to Article 47 of the Constitution. The right to a fair administrative action. Article 47 is further to be read together with the fair administrative. That act, Your Honor, informs any investigation affairs as far as the applicant is concerned, and as it has been submitted on a number of occasions before you. The applicant has no business moving what is otherwise, even the name tells us, internal affairs. So, Your Honor, you have no business being dragged into the internal affairs of the applicant and the respondents. Moreover, Your Honor, during the conduct of these internal affairs, at the very least, the respondents should be given a written reason.
Your Honor, are these parts of the rejoinder?
Your Honor, these are points of law.
Points of law.
Yes, they're points of law.
As long as it's not going to the fact.
Thank you, Your Honor.
It's flowing from your submissions on section 87. Since it's law and it's building for the authorities.
Yes. Thank you, Your Honor. Your Honor, I'm almost concluding. Yes, Your Honor, just to mention that the Fair Administrative Actions Act of the year 2015, under section 4, 5, and 6, requires that any administrative actions conducted by anybody, including the applicant, the respondents must be given written reasons. So that if at all my senior counsel for the applicant has the authority to come before you, the very least he should be doing first is to give you the written reasons that they served on the respondents, so that they can, at the very least, give him authority to appear before you. Your Honor, I close by restating what I had mentioned, is to urge the Honorable Court, as we help the applicant and his representative to put their house in order, let us not surrender the rights of the respondents at the altar of sacrifice. Let us give them their liberty as we fight out on other legal issues, Your Honor. I respectfully submit. Thank you.
Can I pour stand up so that we see you? And
No, they are not here. They are not here.
Or maybe
They have done a press statement in their office. I've only brought to the attention of the court.
Okay, thank you. Although from my training, which I think you also, and also blind, I am guided by your submissions and the application. Even if I see, I am blind. Even if I hear, I am blind. Right? Thank you so much, all of you, for being calm. At least it is good for all of us when the advocates and the prosecution counsel, you interact calmly. But you can see you have done quite a lot of submissions. You have given me authorities. I am not going to give you a ruling on the spot. This ruling will have to come on Wednesday. Unfortunately, to enable me come up with a well-reasoned ruling, Mr. Onge, stand up kindly and address the
Yes,
court.
I was going to say this.
Yes.
With access rights to counsel and access rights to their relatives. He wanted to listen to me because he had told them that nobody should see the first respondent. So either that they be granted access to advocates and their relatives and whoever wishes to visit them within the confines of the local court.
And competence. Now, Your Honor, the investigating officer has no problem. The government has no problem with the respondents being accessed by their relatives and counsel.
No. Yes.
No, before. I did have the whole of Friday night, Saturday night, Sunday up to today morning. These officers have been separated. There's one at Capitol Hill as a means of torture, as a means of isolating them from their colleagues. I have instructions that we make that they all be accommodated
In the same house.
The reason as to why we are raising the conduct of this, we are on one police station to another.
Yes.
Could they be accommodated in one police station? Unless there is a serious.
Your Honor, on a very serious note, provided that Your Honor orders that they be detained at non-police stations. Why? Because, Your Honor, obviously they are a very serious matter, Your Honor, and therefore there are obvious reasons that necessitated their separation, Your Honor. And Your Honor, we are also hoping that some of them may or likely to cooperate and not want interference of whatever nature. Therefore, Your Honor, we are kindly asking that they all be separated. They are within Nairobi, Your Honor, within 3 kilometers of each other, and the investigative agency is one, prosecution team is one. So, I mean, it should not be put.
Your Honor, this is a matter even that His Excellency, the head of the state, has been involved in.
We are now going beyond, we are
Yes,
going
so,
beyond what is important.
so the court can also be involved.
I am involved.
Thank you.
That is what I trust in the court. The nature of the court, you can see the nature of the court, terrorism and banditry, transnational organized crime, any law and the rights of the suspect or any person who appears before this court. My issue would be whether these accused persons or suspects rather, are held in seclusion to the exclusion of visitation by relatives. The IO has said he will allow the advocates access as well as the relatives. And I would add, if there are any among them who want to pray, allow them to pray, allow them change of clothing. If there's any one of them who is on treatment, on drugs, maybe chronic illnesses, allow them to have drugs. Now beyond that, as to where they'll be accommodated, I can only say they are police officers, they are senior police officers, accord them the respect and the rights that you accord others. There's no charge sheet before me, they are only being investigated. So I would say that wherever you detain them, ensure that they are safe, number one, their rights, especially the right, the human dignity. With human dignity, I mean change of clothing, toothbrush, and what I have said, treatment. The rest is not within my purview. Where they are held, I don't even want to get to know which bedroom or which cell, except I would need the names of the police station. If it is Capitol Hill, if it's Kileleshwa, if it is Kilimani, allow the advocates to know so that they don't go groping around. Is that understood?
Yes, Your Honor, we will let them know, but
yes.
I'm sure they are. Your Honor, I'm informed that they'll be retained where they were.
Okay. You are happy with that now?
Yeah, very, very interesting. So, Kiaret, the DPP take that with
This court has a record of mistreatment of any suspect.
These ones have been treated very well.
They have
But
been
I'm
treated
always
very
telling the state,
Yes.
whenever they are prosecuting other state officers,
Yes.
let them know that these things continuously change, that now we are changing them every time in 5 years, it can change and be different.
Thank you, and see you on Wednesday.
When a new person arrest.
Officers who are brought to court, instead of them being charged, a miscellaneous application was done by the Internal Affairs of the National Police Service Commission seeking for them. Raise such an application is the DCI or the Functional National Police Service Commission or the DPP. The act that creates, the section that creates the internal unit, section 87, allows it to deal with complaints of police officers who have snatched another police officer's wife. Petty discipline matters, not issues of two Indians who are dead. This is a national issue and an international question. It's not about police officers who have been drunk and disorderly, making noise and such things. That is what the internal police unit is supposed to do, to deal with the discipline of police officers within the police lines and outside, the relationship. So we raised that serious question, and the court found out that our arguments are cogent, so we could not proceed with the application for 30 days. We are coming for ruling on that application on the on Wednesday. We put it to the court very expressly that the mandate to deal with this matter is provided for by Kenyans in an entity called IPOA. It is IPOA that needs to investigate this matter. It is IPOA that needs to prosecute these people. But anybody trying to bring an illegal entity, it is a legal entity, the internal unit is an illegal entity, but it is illegal in terms of coming to court. And even contemplating detaining police officers for 30 days, just because the head of state raised this question. As the defense team, we are determined to fight to the Supreme Court to ensure that these 4 police officers and any that they want to arrest is protected. As we clearly put it very clearly, these police officers who are junior are being forced, coerced, intimidated to implicate their bosses, their superiors. Their superiors are not in this matter. Issues about abduction can only be dealt with when we have facts. We have not been given facts, and we have raised that question of law. We hope the court will agree with us, and if the court will not agree with us, we'll move to the High Court to make it very clear that that is not an issue. 2, remember also we are heading to the question, if indeed the state is saying the 2 Indians disappeared while in the hands of the police, then the law, this criminal procedure code section 287 or 387 or 383 provides for an inquest. These police officers should be exposed to an inquest, a public inquest, because the surroundings of the death of these 2 people, of these 3 people, is not clear. So we shall be pushing the way we pushed in the Kianjakoma matter, that these 4 police officers are innocent. They are completely being framed up. And you have seen it when I raised it, that they are being framed up. You've seen now the entity coming to bring them to court is not an entity known by law. It is an entity's job who is supposed to deal with domestic issues between police officers.
The Internal Affairs Unit of the National Police Service, whose mandate, as I've indicated to the court, to receive and investigate against the police.
Allow me to clarify. That's good. If it is a preliminary objection, then you needed to tell me that you are raising a preliminary objection on points of law, and with respect to the purpose, and then whether you are going to go full objecting to.
We are objecting simply that a busybody called the Internal Affairs Unit of the National Police Service Commission is purporting to appear before you on matters it does not have jurisdiction.
Okay, that will be sufficient. As now notice, then now you can respond.
Thank you. Now, Your Honor, that notice has just been given over to the prosecution and the court just this minute, or in the alternative, whatever direction the court will increase on point of law.
No, it should be. No. Section 87, I think you have a computer. Get one back to it and let me respond, because just, do you have the restriction? You don't have it, that's all.
I agree with the defense, but that should not, your inability to respond on the spot does not abandon from proceeding. Is that okay? This is a court of law, and we all need to be calm, isn't it? We all need to be calm. And on this side, we will get you more seats so that I can have all the advocates find somewhere to sit. The security personnel, there are 2 chairs here. I also need protection from you, so I need yeah, 2 of you can sit there kindly. There is even another chair here. Now the advocates sit. After he'll hand over to the next advocate like that. All right? So I need everyone to take a seat. That is the
That is the mandate of the Internal Affairs Unit. Nowhere is it contemplated that it can come to this.
Because that will be acting after violence. When a body acts after violence, it lacks the jurisdiction. It also makes the Honorable Court lack selected jurisdiction. Such a body acts after violence, we don't have to look at the merits of whatever they are doing. So, it's not tried or kidnapped or disappeared, and the allegations of extra judicial killings. What is important is, has the court been moved by the proper person and in the right manner? If such is not the case of this application, if it's not brought within the confines of what the law.
Right. Thank you so much, all of you, for being calm. At least it is good for all of us when the advocates and the prosecution counsel, you interact calmly. But you can see you have done quite a lot of submissions. You have given the authorities. I am not going to give you a ruling on the spot. This ruling will have to come on Wednesday. Unfortunately, 20 people will come up with a well-reasoned ruling. Mr. Onge, stand up kindly.
The only request then we could make is what my colleague pointed out to, that we may wish to request that the arrangement that was subsisting over the subject, I know the IO is here, then that nobody should see the first respondent. So let's plead that the arrangement that was subsisting up to today remains, but we have a rider that they be granted access to advocates and their relatives, and whoever wishes to visit them within the confines of the law. That's all.
There's no problem with the respondents being accessed by their relatives and counsel. They'll be allowed access, Your Honor, and we'll come back on Wednesday. What time for the ruling?
9
a.m.
There are 2 at Kilimani Police Station and 1 at Kilelesho.
Yes.
Simply as a means of torture, as a means of isolating them from their colleagues. I have instructions that we make that they all be accommodated in 1 police station.
Allow me to ask, do they all live in the same house?
The reason as to why we are raising the conduct of this, we are only asking that unless there is really any justifiable reason, lawyers are jumping from one court, 1 police station to another, could they be accommodated in 1 police station? Unless there is a serious risk for them that they can break and escape.
Right.
I don't know what justification was there to place them separate.
Yes, please actually go on. Your Honor, this is a matter that I will not urge you to get involved with, provided that Your Honor, on a very serious note, provided that Your Honor orders that they be detained at non-police stations. Why? Because, Your Honor, obviously there are reasons why investigators separated them, Your Honor. This is a very, very, very serious matter, Your Honor, and therefore there are obvious reasons that necessitated their separation, Your Honor. And, Your Honor, we are also hoping that some of them may or are likely to cooperate and do not want interference of whatever nature. Therefore, Your Honor, we are kindly asking that they all be separated. They are within Nairobi, Your Honor, within 3 kilometers of each other, and the investigative agency is 1, prosecution team is 1. So, I mean, they should not be put together simply for the convenience of the lawyers, Your Honor. Just look into that, Your Honor.
You're not suggesting that you're not...
and goes beyond the boundaries of Kenya must come here. The court is interested in the safeguarding the rule of law and the rights of the suspects on any person who appears before this court. My issue would be whether these accused persons, or suspects rather, are held in seclusion to the exclusion of visitation by relatives. The IO has said he will allow the advocates access as well as the relatives. And I would add, if there are any among them who want to pray, allow them to pray. allow them change of clothing. If there's any one of them who is on treatment, on drugs, maybe chronic illnesses, allow them to have drugs. Now beyond that, as to where they'll be accommodated, I can only say they are police officers, they are senior police officers, accord them the respect and the rights that you accord other people, all people who come before court. As at now, they are actually, there's not being investigated. So I would say that wherever you detain them, ensure that they are safe, number one, their rights, especially the right, the human dignity. With human dignity, I mean change of clothing, toothbrush, and what I have said, treatment. The rest is not within my purview. Where they are held, I don't even want to get to know which bedroom or which cell, except I would need the names of the police station. If it is Capitol Hill, if it's Kileleshwa, if it is Kilimani, allow the advocates to know so that they don't go groping around. Is that understood? The idea?
We will let them know, but
yes.
I'm sure they are